Thank you, Tessa. Attorney David Aylor joining us right now for Trial Thursday. It is time to talk about slipping and falling in stores or restaurants and what to do if it happens to you. Counselor, thanks so much for joining us. We do appreciate it. So let's talk about this. A lot of it has to be spatially if you're in that store, in the restaurant, but then there's got to be kind of a gray area right outside on sidewalks and curbs, things like that. That needs to be taken into account.
Absolutely, and they're going to be responsible for those sidewalks and the curbs and even the parking lot within the area of that restaurant or that store. But I think probably what you see often, and I know a lot of calls that come into my office, is after something like this happens, people really don't know what to do, particularly if they have injuries.
What do you need to do? I assume you need to file a police report or go see a doctor and make sure that you get that documented medical evidence.
Well, first thing you need to document is that it actually happened there. Too oftentimes people will take a fall, take a slip, and then say, you know, I was hurt, but my friend was there, or my husband or my wife, and so they helped me up and we kind of left, and then we decided I needed to go to the emergency room. What you should first do, if it's reasonable and it's not too much of an emergency situation, is make sure the management of that restaurant, that bar, whatever it may be, is aware of what happened and documents it themselves. Because otherwise it's going to be hard to come back and have a liability issue on that restaurant, on that business, if in fact you just get hurt and leave and tell no one.
Absolutely. Everybody carries a cell phone with them these days. Every one of those cell phones pretty much has a camera. Can you document it that way? Would that be admissible in a court of law?
That would be very important to do if you can do it. Obviously, again, we're talking about some circumstances. You can't sit there and lay out everything you need to.
Right.
But if you can take a couple of pictures, if, for instance, it's a tear in the carpet, you know, take a picture of the tear. If it's wet floors, show some of the puddles. So when it comes later, you can say, hey, here's what I fell on. We've got a report of that, and here's a picture 3 minutes afterwards of showing what it was I fell, so that then you won't have so much problems dealing with the restaurant, dealing with the insurance companies, and moving forward to get help for your bills and everything that comes.
We're not talking about taking a selfie while you're on the ground in pain or anything like that.
I mean, that may be a little too far.
Yeah,
although,
probably.
but you know, if you are the only one there, and sometimes people are by themselves, you know, ask the person that you report it to take a picture. That is very important if you can get the picture, because sure enough, a lot of these things are very temporary. So by the time you came back, it oftentimes is gone, so it may be harder to prove at that point.
We've often seen those giant yellow cones or something that says, you know, wet floor. Is that enough to cover you if you own an establishment like this? If you just put, there's a giant puddle and you put a sign like that out, is that enough to cover you?
It's going to be specific to the situation. Sometimes it can be, but it depends on exactly where it is, how close it is to where the actual water is or liquid that's on the ground. Oftentimes, you know, there's certain things that the stores and restaurants are going to be responsible for that they will say is outside the scope of, you know, their responsibility, and that's not going to be true. If in fact you fall based upon something that happened, even if they weren't aware of it, you show that they should have been, and then you move forward from there.
In your profession, you probably see a lot of these cases, and a lot of people are willing to settle. At what point, in your opinion, do you want to settle versus taking this thing to trial?
Well, you never want to settle under any terms until you're completely whole, and that means completely whole or to the point that you can't be any better than you are, and that means from a physical standpoint, based on, you know, whether it be therapy, chiropractic, or any other type of medical treatment. A lot of times, often when people report these things, or an adjust claimer, insurance adjust claimer will call and talk with the people prior to having a lawyer. They'll try to settle quickly, similar to car accidents. You don't want to do that. You want to hold off, because if you take the money or you take the settlement early, you can't move forward past that, and all the other bills are yours.
Is there a statute of limitations in one of these cases?
Generally looking at 3 years, but the sooner that you get involved, because the insurance company will contact you soon, so I suggest getting an attorney and trying to move forward that way, because if you get taken advantage of, you can't go backwards.
Great tips right there. Attorney David Aylor, thank you for your time, sir.
Thanks for having me.
Do appreciate it. Stay with us. Our good friends from La Fontana up in the studio kitchen. That's next.